It's my delight then to turn and introduce both of our speakers more fully. Julian Burnside AO QC is a distinguished Melbourne barrister. After completing a Bachelor of Economics and Laws at Monash University, Julian was called to the bar in 1976 and took silk in 1989. Julian has acted in a number of high-profile human rights cases, including as leading counsel for the asylum seekers in the highly publicised Tampa litigation. He has an extensive pro bono practice, a large percentage of which concerns acting for refugees. He's the immediate past president of Liberty Victoria, formerly known as Victorians' Council for Civil Liberties. Julian's most recent publication is Watching Brief, Reflections on Human Rights, Law and Justice. He's also published a compilation of letters written by asylum seekers held in Australia's detention camps, entitled From Nothing to Zero. Julian was elected a living national treasure in 2004. In 2009, he was awarded an Officer of the Order of Australia for his services as a human rights advocate and for his services to the arts and the law. From this very brief resume, and I've cut a lot out of it, Julian is thus extremely well qualified to address us today on the need for a Federal Bill of Rights. Our other speaker, Jeremy Moore, was admitted to practice as a solicitor in South Australia in 1980, and he's practiced extensively in South Australia and also in the Cook Islands. Jeremy has also done a lot of pro bono work with refugees in South Australia. I've heard him refer to himself as a garden variety lawyer who got cross. He's been particularly instrumental in obtaining legal access to asylum seekers in detention at Woomera. He was the co-founder of the Woomera Lawyers Group, which we will hear more about today. In 2002, Jeremy was awarded the Centenary Medal for his work with refugees and was a joint recipient of the National Children's Lawyers Award in that same year. From the 1st of April 2008, Jeremy was appointed the President of the Guardianship Board. Whilst a prominent human rights advocate, Jeremy is unconvinced that a Bill of Rights is the right tool to promote and protect human rights in the Australian community. Thus, he's not convinced by Julian's position. Please join me in welcoming to speak first Julian Burnside, AO QC.
Thank you all very much, and thank you, Gabrielle. And also, can I add my thanks to Emma Riggs and her organising committee, who've done a really remarkable job in arranging this event. And can I also take the opportunity, since Jeremy is the other speaker, to make clear right at the beginning that the Adelaide legal profession, and notably people like Jeremy and Claire O'Connor, who's here, and several others, led the field during the time when asylum seeker issues were at the front of mind. The Adelaide legal profession did an immense amount of work, unpaid, for people held in Australia's detention centres. Now, can I start by trying to establish some common ground as a foundation for the discussion? The first is, what do we mean by human rights? And the clearest modern articulation of it is in the Universal Declaration of Human Rights, which was entered into force on the 10th of December 1948. And interestingly, the Australian team that participated in the creation of the Universal Declaration were among the key architects of it. The Australian team contributed far more than could have been expected from a country with the modest international profile that Australia had then, or for that matter, has now. And it's interesting and significant that it was an Australian who presided over the General Assembly on the 10th of December 1948 when the Universal Declaration was adopted. And it's worth bearing in mind that the Universal Declaration was the response of the world community to what had happened in the lead up to and during the course of the Second World War. Eleanor Roosevelt was, of course, the original proponent of it, and the preamble to the Universal Declaration includes these words: whereas disregard and contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind, and the advent of a world in which human beings shall enjoy freedom of speech and belief and freedom from fear and want has been proclaimed as the highest aspiration of the common people, then they went on to declare the various rights that ought to be protected by the rule of law. We helped write it and we signed it, and yet so far we have not as a nation decided that we're willing to protect human rights by the rule of law. What rights are we talking about? The Victorian Charter of Human Rights and Responsibilities identifies the rights which that instrument protects, and they're the same rights which a federal instrument would protect if we decided to go down the path recommended by Frank Brennan's committee. Now, it's interesting. I'm going to run through some of these rights, and I invite anyone who thinks that any of these rights ought not be recognised or protected to indicate so, because it's kind of hard to disagree with them, like equality before the law, the right to life, freedom from torture or cruel, inhuman or degrading treatment, freedom from forced work, freedom of movement, privacy and reputation, freedom of thought, conscience, religion and belief, freedom of expression, peaceful assembly, freedom of association, protection of families and children, taking part in public life, fair hearings in a court, the right not to be tried or punished more than once for the same offence. You know, these are kind of self-evident things that we recognise as useful, worthwhile values in a civilised democracy. So then the next question is, well, what's a Bill of Rights? And this is where we start getting a bit of confusion in Australia, because many people in Australia think a Bill of Rights means the US Bill of Rights. George Williams in New South Wales did a survey a few years ago in which it turned out that more than 50% of the people surveyed thought we had a Bill of Rights already, which we don't. And some of them showed as evidence of the fact that we had a Bill of Rights that when they're picked up by the police, they can take the fifth. Now, I like American television courtroom dramas, but it's not a good way to learn law, and especially on matters as fundamental as this. The next thing to bear in mind, and I think this would be common ground with Jeremy, is that a right can't properly be described as a right if it is not recognised in law and protectable by the law. If it's not recognised by the law, then it's not a right at all, it's just a hope. Maybe a worthy hope, but not anything better. Because if you can't enforce your rights, then they aren't rights. Now, as you've heard, the Brennan Inquiry recently recommended a number of things, including the adoption by the federal government of a Charter of Rights or Human Rights Act. Let's not get mixed up, let's not get confused by the names. Bill of Rights, Charter of Rights, Human Rights Act, they're all the same thing. They can vary in their content from the extremes of the US Bill of Rights through to the rather more orthodox Charter of Human Rights and Responsibilities that we have in Victoria, or the Human Rights Act, which the ACT has, and which in substantial effect is the same as the Victorian model. So don't think a Bill of Rights means a US-style Bill of Rights. And I stress this because a number of the people who squawk in opposition to a Bill of Rights advance arguments which are absolute nonsense unless they're opposing a US-style Bill of Rights. If they're talking about a US-style Bill of Rights, their arguments are fairly good. But no one in Australia is asking for a US-style Bill of Rights, and so the criticism of a Bill of Rights is simply misconceived. The committee also recommended an increase in education in relation to human rights in Australia, and George Williams' survey suggests that that's probably overdue. It also suggested, usefully, an audit of all existing federal legislation and federal policies and practices to see whether they are compliant with the sorts of rights that a charter would protect. And they recommend that regardless of whether or not a charter is adopted. And as you've heard Gabrielle say, they recommend the introduction of a Bill of Rights along the dialogue model that we have in Victoria.